Today's workshop will be on how to file a rent increase or decrease. I'm Fred Tran, the Deputy Director of the Rent Program in Richmond, California. Presented are the topics that will be covered during this workshop. We'll go over the purpose, overview of the ordinance, properties subject to the ordinance, who can file a petition, tenant rent adjustment petition, landlord rent adjustment petition, how to file, and finally, an overview of the process. The mission of the rent program is to promote neighborhood and community stability, healthy housing, and affordability for Richmond tenants through the regulation of those landlord-tenant matters that reasonably relate to rents and evictions while maintaining a landlord's right to a fair return. The rent ordinance has two main components: rent control and protection for evictions, known as just cause. In the next slide, we'll discuss the types of properties that are subject to rent control and eviction protections, and further details will be provided later in the presentation. Rent control means a landlord cannot charge above the maximum allowable rent, also known as MAR. MAR is calculated as the base rent plus the annual general adjustment. MAR can be adjusted upwards or downwards through the petition process. Just cause means a landlord cannot evict a tenant arbitrarily, essentially with no cause. One of the 8 just cause reasons for grounds for an eviction must be present in the city of Richmond. If a just cause is not provided, a landlord cannot terminate a tenancy or evict. Which properties are covered by the rent ordinance? Fully covered units are subject to both rent control and just cause for eviction protections. These are multi-unit properties, duplexes, and larger, built on or before February 1, 1995. Partially covered properties are subject to only just cause eviction protections and not subject to rent control. These include government subsidized units, including Section 8. Renters are regulated by deed restrictions or the housing authority. Properties exempt under the state's Costa-Hawkins Rental Housing Act are also considered partially covered units. Costa-Hawkins exempts properties with single dwelling unit on a single parcel and newer construction built after February 1, 1995. Single dwelling unit properties refers to condominiums and single family homes where there is no subdivision or in-law unit. Some properties are fully exempt from the rent ordinance, meaning no rent control or just cause applies. These include room rentals in a landlord's primary residence where the landlord and tenant share a kitchen or bathroom. Full exemption also applies to owner-occupied single-family homes where the landlord rents out a permitted accessory dwelling unit or ADU. Retirement homes and short-term rentals are fully exempt. The rent ordinance creates exemptions for accessory dwelling units or ADUs. This chart clarifies different scenarios with these exceptions involving the ADUs. The treatment of the ADU under the ordinance depends on whether the unit is permitted and whether the owner lives in the other unit. If the ADU is permitted and the main house is the owner's primary residence, the ADU would be fully exempt from the ordinance, meaning not subject to rent control and just cause. It is the first example provided. If the ADU is not permitted, it would be treated as a second dwelling unit and subject to both rent control and just cause. Please see example 2 and 4. If the ADU is permitted and the main house and the ADU are tenant occupied, they exempt from rent control and still subject to just cause, which is the third example. If the main house is a tenant occupied and the ADU is owner occupied, the rental is subject to rent control and just cause. That is the fifth example present. Permitting is handled by the Planning Division, Building, and Code Enforcement, who also conducts the inspections. Who can file a rent adjustment petition? Any tenant or landlord subject to the rent control provisions of the rent ordinance may file a rent adjustment petition. Tenants who believe their rental unit should be subject to rent control provisions but are unsure may file a petition. These cases usually involve homes that have been subdivided, have converted garage, or have additional dwelling units. Tenants or landlords may file the petition themselves or have representatives file for them. Units not subject to rent control may not file a rent adjustment petition. These are usually properties that are only under the just cause for eviction protections, such as the single-family home, condominiums, or rental subsidized by the government, such as Section 8 or tax credit unions. If you are unsure, we recommend you contacting the rent program at 510-234-7368 to speak with a housing counselor. Tenant petitions for rent adjustment. Tenants have the right to file a petition for various grounds for the rent adjustment. The grounds consist of excess rent due to overcharge above the maximum allowable rent. If there is a decrease in space, services, substantial deterioration of the rental unit, or documented habitability issues. Tenant can file for a reduction in number of tenants allowed. Finally, petition for failure to pay relocation payments. There are 4 adjustments available for landlords to increase beyond the MAR. Primarily, petition to increase rent for maintenance of net operating income, or MNOI petition is available for a landlord who is entitled to a fair return. That MNOI petition is not guaranteed market rate rents. It looks at income and expenses, pre and post rent control, to determine whether net operating income has decreased. The owner has the right to obtain the net operating income equal to the base year, adjusted by the Consumer Price Index. It shall be presumed this standard provides a fair return, and we suggest maintaining all of your records. The second adjustment is to increase the number of occupants relative to the initial occupancy. There are protections for certain family members. Rent cannot be increased when there's a child or parent moving into the unit. Additional space or service for both parties agree in a rent adjustment. For example, a tenant wants an additional parking space that isn't included in the original rent. A landlord can request a reasonable increase. Landlord can petition to increase rent for restoration of denied annual general adjustments. And finally, a petition to increase in security deposit is available due to additional pets. How to file a petition. The rent ordinance allows for rents to be regulated and adjusted through the rent adjustment petition process overseen by a hearing examiner. Think of the hearing examiner as a judge. The process is similar to a court case, but the process is less formal as it is an administrative process performed and completed through the rent program and its staff. Please note, there is no cost to file a petition. Presented are the steps to filing a petition. The first step is to contact the rent program service analyst to discuss your case and learn about your rights under the rent ordinance and rent regulations. Complete the landlord or tenant packet. This form must be completed with all signatures and filed to be deemed complete. Third, complete the appropriate attachments. Tenants or landlords can petition for multiple grounds at the same time. Step 4 includes your documentation or evidence to support the petition claim. When filing a petition, the petitioner should submit the lease, any letters, emails, texts, photos, videos, inspection reports, or any other documentation to support the grounds of the rent adjustment. Remember, the hearing examiner's rent adjustment decision is based on a preponderance of the evidence. Next, the party must be served a copy of the petition with all support. Then a proof of service needs to be completed and submitted with the original petition to the rent program. An important part of the petition process is the requirement that the petitioner must complete the petition packet, which includes the forms, attachments, documentation with a proof of service. When submitting a proof of service, the petitioner is declaring under penalty of perjury that they have served a copy of the petition to the other party and the rent program. If additional documentation or support needs to be included in the petition after the original submittal, an additional proof of service is required to be submitted. File the original petition via mail or email. Presented is the list of what a completed tenant or landlord petition has and is required. A complete petition is submitted to the rent program. Tenant petition will include the tenant petition packet, attachment form either A, B, C, or D, the proof of service, and supporting documents. A completed petition for the landlord will include the landlord petition packet, attachment form A, B, C, D, or E, proof of service, supporting documentation. Please note if additional documentation or support needs to be added after the original petition has been submitted, a proof of service will need to be completed. The overview of the petition process. Once the petition is received and reviewed for completion by the program staff, an opportunity is given to object the petition within 21 calendar days of the mailing of the notice. After 21 days, the objection deadline is over, a settlement conference and hearing notice will be scheduled, and the hearing notice is sent to all parties. Each party can request continuance in writing. After the hearing, the decision is rendered, which can be appealed by each party within 30 days of the decision. Before the hearing starts, each party must introduce themselves to the record. The hearing examiner may not discuss the case unless all parties are present. The settlement conference and hearing can only proceed if all parties are participating, unless there is a complete failure to appear by the responding party, in which case the hearing can still move forward. A failure to appear by the petitioning party will generally result in a dismissal of the petition. Each party and the corresponding objection will be presented openings for a possible settlement. Each party may have submitted evidence or an objection. Additional documentation to be reviewed during the hearing in the form of exhibits must be provided to the rent program, and all parties no less than 2 days prior to the hearing. The hearing examiner may question each party present about pre-filed testimony or evidence to better understand the party's position in their case, or ask to challenge their credibility or accuracy. Additionally, parties may be asked probative questions about the party's evidence or testimony. At each hearing examiner's discretion, each party may have an opportunity to challenge the evidence presented by the other party. Evidence may be presented in rebuttal to disprove or contest new evidence presented by the other party. The hearing examiner will close the hearing and/or decide to keep the case open for further analysis to decide later on how to continue. A written decision will be sent to all parties after the hearing. The decision is likely to be sent within a few weeks, up to a few months after the hearing has been completed. Each party has the right to appeal. Any party may appeal the decision of the Richmond Rent Program hearing examiners within 35 calendar days after the date of the mailing of the hearing examiner's decision. If appealed, the decision will be reviewed by a 5-member board who act as a quasi-judicial judge. The board may affirm, reverse, or modify the decision of the hearing examiner. Filing a timely appeal will hold the finality of the hearing examiner's decision. Filing a late appeal is possible, but the party must state the reason in writing and include with the appeal the filing and ultimately does not stay any portion of the hearing examiner's decision if late. After a timely appeal is filed, the appellate and respondent are informed by the program of the requirements to appear and participate in the appeal hearing. Any party who wishes to appeal the rent board's decision may seek judicial review by filing a writ of administrative mandamus with the Superior Court within the jurisdiction. Please contact our rent program with any questions or comments. You can contact us at 510-234-7368 or at www.richmondrent.org. This concludes the workshop. Thank you for your time.